Good morning.
Good morning, Your Honor.
Morning,
Yeah.
Mr. Webster and is it Mr. Varghese? I'm not sure.
It's Varghese, Your Honor.
Varghese, thank you.
Yep,
Okay.
no problem.
So let me ask a couple of preliminary questions, just so we can figure out what all we are doing. Um, so this is down for a hearing in the matter of Carr versus Pig. First question I have is an administrative appeal. Does anyone have a court reporter? And if so, who is that person so I can give them a heads up about calling the case? Just a reminder, I think my staff attorney's communications note that there is not anyone. The court does not provide our court reporter for civil takedown matters. So, do we have a court reporter?
We for the petitioners, we do not, Your Honor. This being an appeal, we're just going from the record as it exists.
Of course, Mr.
And
Vargas.
don't,
Oh, I'm sorry.
I was just going to say, and do not anticipate presenting any testimony or anything like that.
Okay, thank you, Mr. Vargas.
We don't either, Your Honor.
Okay, just making sure. Okay, well, we will go ahead. And the last thing I will let you know is because this matter is taking place by Zoom, it will be live streamed. And so while certainly there are a number of parties and each of those parties has a right to be present on the Zoom and observe the proceedings and participate in the proceedings to the extent they would be called upon to do so. It can get a little clunky with lots of people on. So just so you know, for anybody that's just here to observe, you're free to stay if you're a party. But otherwise, there in a moment, we will have a live stream that you can find on the court's website under my name. So just for those of you that are interested. Okay, so let's go ahead and get started. What I have in front of me is a petition for a petition filed by for administrative review by the people that I believe to have been believed to be the electors appointed to vote for the Georgia Green Party's presidential and vice presidential candidates. And I understand this to be a ballot access issue. My understanding is that the respondents in this case, Mr. Pig, Ms. Smith, and Ms. Waymer, are voters in Fulton and DeKalb County who have challenged the access to the ballot of the Georgia Green Party. Now, I also understand, and thank you for addressing some of that issue in your opening brief, Mr. Webster. There is this other entity out there. I believe that the correct designation is the Unified Green Party of Georgia. And that party also has gone through a process, albeit I think a different one, to designate its vice presidential and presidential candidate, who are the same person, the same two people, right? Or Dr. Stein and
Dr. Ware.
Dr. Ware. Thank you. And so the reason I'm outlining all this for you is what I typically do with these hearings is try and start with what I think I know about your case from having reviewed the record and the briefs, and then let you start off with, nope, this is what you got wrong, or this is what I need to add, so that you can direct me in the right way. A lot of this comes down to, as I understand it, the record below, the challenge was made by the electors, or excuse me, by the voters, Mr. Pig, Ms. Smith, and Ms. Waymer, who at the administrative law judge step, the administrative law judge determined that although the Georgia Green Party was a political body for purposes of the election and the election chapter and title of the code, that they had not complied with subsection OCGA 21-2-172G, in that at the hearing, Mr. Esco, speaking on behalf of the Georgia Green Party, represented that that the Georgia Green Party had not obtained ballot access in 20 or more other states. I understand there was some testimony about the fact that some of that was they were in the process of trying to secure such access, but some of it is a scheduling issue, which I think I saw front and center in your opening brief, Mr. Webster, regarding this issue of the timing of the requirements of the Secretary of State's office to provide that information to qualify under subsection 172G. That ultimately, as I understand it, the ALJ said that the Georgia Green Party electors were not qualified to have access to the ballot. And that decision was affirmed by the Secretary of State, who added an additional finding regarding the lack of affiliation, formal affiliation between the Georgia Green Party and the National Green Party. I don't know what the correct title designation is for that entity. So that's where I think we are. I understand procedurally, of course, this is an appeal, so the court is limited to the record and the record below, which the court has reviewed, albeit maybe not quite as deep a dive as I would normally do because I just got it yesterday, but I did get it, and I have looked at the case law. Before we go into too much detail, one issue that I wanted the parties both to address from a procedural perspective. I don't think there's any doubt that the Secretary of State's final decision regarding the ability of the Georgia Green Party to access the ballot has been finalized and is properly before the court on this request for appeal. But the request for appeal also says, we'd like for you, Judge, to address the Secretary of State's letter saying that the Unified Green Party of Georgia does have access to the ballot. And I want to start with, is that issue properly before the court before I go off on a tangent of thinking about things that I should not properly be considering? And if you could, for a moment, just start with that issue, and I'd like to hear from both of you, and then I really will throw it open to you, Mr. Webster, to address that larger issue.
Okay. Well, thank you, Your Honor. And by the way, thank you for doing this by Zoom. You saved me 6 hours of round trip driving doing this
Well,
by Zoom, and I very much appreciate that.
glad to help,
All
sir.
right. In the order that you presented it to me, let me start off with talking about a couple of the things that you said you understand. The testimony from Mr. Esco regarding ballot access in 20 states is not quite correct. It's not far from correct, but it's not quite correct. What Mr. Esco actually testified to was that it was because of this August 23rd, 2024 deadline that the Secretary imposed. It was so early compared to the other states' deadlines that there were several states that we just couldn't get documentation from. Now, the fact is, and I don't think anybody can dispute this at this point, Dr. Jill Stein and Dr. Rudolph Ware do have ballot access in 20 states. And now to get to where you were taking me at the end of this thing, the reason we put the letter Exhibit C to our petition was to demonstrate that really it's no longer a factual question of whether or not Dr. Stein and Dr. Ware have ballot access in 20 states, because the Secretary stated in that letter that they had done an independent confirmation of the fact that they had access in 20 states. And that's going to be pivotal to the arguments I'm going to be making in a few minutes. But to specifically address the question you asked me, is the request to basically rule that the Unified Party is not qualified, is that an issue that you should take up on appeal? Recognizing that I did say that in my petition, and it's this flurry of litigation that makes an attorney worry, am I covering all my bases or not? It probably is not an issue for you to rule on in this appeal. But I do think the court should take notice of how the Secretary has proceeded as it affects my clients on the appeal that they are bringing, which I do think is squarely before the court.
Okay.
So I would ask that the court mainly focus on whether or not the rulings of the ALJ and the Secretary that the 16 elector candidates are not qualified. That is the central issue on this appeal, and I think for today's discussion.
Okay. Thank you. Mr. Varghese?
Yeah, I think the issue of whether the presidential electors for the Unified Green Party of Georgia are not properly before the court in this appeal, and I think Mr. Webster acknowledges that.
Okay.
Here we're dealing with electors for the Green Party of Georgia.
Okay, and that leads me, the reason I started with that, first, thank you both for letting me know that y'all are in some agreement about that issue. There is this other case out there in front of a different judge on my bench that also seems to involve one of the Green Party entities, but because it's not my case, I'm perhaps not as well versed, but it doesn't seem to be a direct appeal. How does the existence of that case affect or not affect what we're trying to do here today, Mr. Webster?
Well, Your Honor, I think you're referring to the case, and I've got the number here. I can give it to you if we need to. It's a suit that Mr. Varghese and his clients filed for writ of mandamus
Mm-hmm.
against the Unified Party. And I think Mr. Varghese will agree with me that the essence of the ruling was that there was an administrative remedy available to the plaintiffs in that case, and therefore writ of mandamus was not appropriate. The judge, and it was Judge Cox, by the way. Judge Cox did not, in my opinion, in reading in his decision, did not go deeply into the arguments that you're going to hear today. But as I understand it, it has resulted in an actual challenge by Mr. Varghese' three clients that is now at the administrative law judge level. Judge Malihi, who has heard all these cases, has got it. That hearing was conducted this week. I understand that the decision has not come out yet from Judge Malihi. Mr. Varghese may know something that I don't know on that.
Well,
Uh,
let me interrupt you for a moment because I am familiar with Judge Cox's rulings, particularly as it related to Dr. West, and then I'm also aware that another of my colleagues has addressed an issue related to the Socialist Party. I'm actually referring to an open petition filed by Mr. Pigg and his colleagues versus the state of Georgia. There now,
uh,
it it's open. Like it doesn't appear to have been processed or ruled on, which is why I had less insight into what is the status of it and what is its effect here. For your benefit, Mr. Webster, it's 24CV011100, and it appears to be styled Mr. Pigg and his colleagues versus the state of Georgia. Mr. Varghese?
Yeah, I could speak to that, Your Honor. That's a declaratory judgment action relating to the candidates for elector on behalf of the Unified Green Party of Georgia. So
Mhm.
different set of electors, and I don't think it bears on the issues before this court in
Okay.
this matter.
Okay, excellent. I just wanted to make sure because I would hate for me to spend time trying to address the issue that's directly presented by these pleadings, only to discover that there's a collateral issue in front of a different court that obviates the need for us to engage in this exercise. So, with that
Certainly understand, Your
understanding,
Honor.
okay,
I
thank
was
you.
just going to offer a brief update on what
Please,
Mr.
yes,
Webster said, just with regards to the administrative proceeding on the Unified Green Party of Georgia
yes.
electors. There has been an initial decision issued as well as a final decision by the Secretary. Both of those were issued yesterday, and both finding that the electors for the Unified Green Party of Georgia are qualified for the ballot.
Okay, okay. So presumably either that will stand or someone will file an appeal and it will go through the same process and be assigned somewhere to this court under a very tight deadline, as I understand the ballots are to begin being distributed on the 17th, which is next Tuesday. Is that right?
I think that's right, Your Honor.
Okay. So with that, let's get down to business. Mr. Webster, if you would go ahead, please, sir.
I will. Thank you, Your Honor. First of all, as Mr. Varghese suggested, I was not aware that those decisions had come down in the administrative thing, uh, which is interesting. I'd like to read them. I think Mr. Varghese and his clients and I and my clients all both agree that those decisions are not correct and they do have an ultimate impact. But I think for today's purposes, we should just talk about the ruling on the qualifications of my clients.
Yes, sir.
Um, Here's the situation that we have. Um, my clients are the 16 presidential elector candidates that were nominated by the Georgia Green Party. Uh, to be qualified as an elector candidate, a couple of things have to happen under Georgia law. Number one, They have to be nominated by either a party or a political body. And in this case, they were nominated by the Georgia Green Party, which is in fact registered with the Secretary of State, and has been since 1996. I mention that because that was one of the initial attacks that was raised by the respondents and appellees in this case. And the judge both the ALJ and the Secretary of State correctly ruled that the Georgia Green Party is registered and has been. The second thing that has to happen is that the presidential elector candidates have to be nominated under 172, 21-2, 172, by the Georgia Green Party in this case. And again, in this case, the ALJ and the Secretary both correctly found that these 16 candidates have been properly nominated under Georgia law, which that involves holding a convention, advertising the convention at least 10 days prior, taking minutes of the convention, and then, of course, being nominated. Again, all of that was done in this case. So that is not a reason to disqualify. And of course, that's the ruling of the ALJ and the Secretary of State. The third thing that has to happen is that the candidates have to submit their declarations of candidacy. And with that, the party is supposed to also file with the Secretary its nominating rules and regulations, which was done in this case. Again, that was found by the ALJ and the Secretary. And the declarations of candidacy must have attached to them the certified minutes of the nomination conventions to complete the filing. And again, that was done. And again, the ALJ and the Secretary agreed all of that was done in compliance with law. So in every sense of the word, the candidates that I represent in this case went through each of the steps required by Georgia law to be eligible to be qualified. The last step is, well, up until July of this year, the last step was that you had to have nomination petition signed by no less than 7,500 verifiable signatures of registered voters in the state of Georgia and who were eligible to vote in this election. Now, up until July, that was the only way we could do it. But then this year, the legislature enacted a new subsection to 172, that is subsection G, which created a new avenue for ballot access. And that statute, I know the court's read it already, and it's in my brief, basically says that any political party or political body that has obtained ballot access in 20 states shall be allowed to qualify their candidates for presidential elector and obtain ballot access. And that's where the path begins to split between what we think is the correct rule of law and what the ALJ and the Secretary did. The ALJ first ruled, as you've already noted, that that my clients did not qualify because they didn't show that they had ballot access in 20 other states. Now, we've advanced some constitutional attacks on that finding. We think the August 23rd deadline is unconstitutional. There's no basis in the statute for it. There's no statute outside of 172 that gives the Secretary any kind of discretion to create an arbitrary early deadline. And of course, as you've already seen, as the ALJ found, this deadline was so early that it prohibited parties like my clients from being able to produce supporting documentation that the Secretary said he was looking for.
Right. But don't we, I mean, for example, election day is on a certain date. Early voting starts on a certain date. And everybody seems to understand that in order to make early voting work on a certain day, and in order to make election day occur on a certain day, that there is a huge amount of administrative preparation that goes into that. And so, I mean, certainly that is the Secretary of State's basis for having that date be early enough so that we're not all, even now at that early date, here we all are less than, 2 business days from when these ballots are supposed to be finalized and distributed.
I agree with that, Your Honor. And I don't know if the court's had an opportunity yet to see the affidavit that was filed in this case by Ms. McGowan, General Counsel for the Secretary. And she basically outlines that problem. And that is that they're supposed to start the printing, I think, or well, they've already started the printing in many counties, but their deadline is next Tuesday under federal law to get it out for basically military people to be able to vote by mail. But that is, excuse me for the label I'm putting on it, the beauty of the situation that we have in this case. We are not asking this court to take Dr. Stein and Dr. Ware off of the ballot. We're asking the court to establish the foundation, the real and the right foundation for which those candidates should be on the ballot. If you rule in our favor in this case, it will not require the secretary to take Dr. Stein and Dr. Ware off of the ballot. What's really happening here is you are determining which of these two parties should be allowed credit for putting Stein and Ware on the ballot because of the implications that come out of 21-2-180. And that's the whole reason we're fighting this. If it was only a matter of getting Stein and Ware on the ballot, it's done. We wouldn't have to fool with this thing. But whichever party gets the credit for putting them on the ballot gets the benefit of 180, which says that if Dr. Stein and Dr. Ware receive at least 1% of the registered votes in this election, then we get to put candidates on the statewide ballot in the next go round without having to go through the petitions and all that stuff that we've had to do all these years in the past. So it's a critically important decision. But the good news is you don't have to worry about taking Dr. Stein and Dr. Ware off the ballot. You're simply deciding whether Georgia Green Party should be receiving the credit for this or whether the Unified Party should be receiving the credit. And that's why it's so important to us to talk about what the Unified Party didn't do. But the bottom line is that this affidavit submitted by Ms. McGowan today, I think, demonstrates the very argument we made about the ALJ's finding. The last state, if I'm not badly mistaken, deadline was September 5th. And had that evaluation, if that deadline of August 23rd didn't exist, but it instead was brought in line with the other states to comply with this 172G, then we would have not had any problem establishing the fact that Stein and Ware had obtained ballot access in 20 states. And that is demonstrated, and this is why I put this letter in Exhibit C, or excuse me, Exhibit B, not C, on our petition. It's just fully demonstrated by the fact the Secretary admits that they conducted their own independent confirmation and determined that Stein and Ware are on the ballot in at least 20 other states. So that ruling by the ALJ that we did not or would not be able to meet the August 23rd deadline is both factually not true, and it does not have any support in the statutes to say that August 23rd deadline could be selected by the Secretary. And as we have demonstrated, the selection made by the Secretary of that date is just patently unconstitutional because it demanded we do something that could not be done. Nobody could have established that fact beyond the Secretary's own independent confirmation. Nobody could meet that criteria in the way that the Secretary interpreted law and the way the ALJ applied it.
Well, let me ask you this though, and in terms of the language of 172G, right?
Correct.
It says political party or political body, and
Exactly.
so doesn't it matter then not that Dr. Stein and Dr. Ware are on the ballot in all 50 states if they are, but that the body or entity that is urging their candidacy has gained access to the ballot. And so, and if that's the case, right, then isn't there more of a lift? Like, in other words, isn't the fact that the Secretary of State has determined that Dr. Ware and Dr. Stein are on the ballots in other states not necessarily dispositive of what the court has to do here, right? Which is, does the Georgia Green Party as a political party or as a political body, which I think is what the ALJ designated it to be at minimum, has um, the Georgia Green Party obtained ballot access, and necessarily the Georgia Green Party is not going to be trying to get ballot access in Alabama, but it certainly through affiliations would do so. And so, if the witness for the Georgia Green Party and I think there's some greater explanation of the nature of the split. Um, if there's a clear separation and split between the Georgia Green Party and whatever this national Green Party is, then how is the Georgia Green Party able to claim credit or get the benefit of the ballot access that's been secured by an entity with which it is not affiliated?
Well, the question the court's asking is, in fact, the new thing that was added by the secretary in its final decision. The answer to your question is this. Neither the ALJ nor the secretary considered the title political body when it was making its rulings. Political body is defined in 212-224 as both a party or an organization, or excuse me, a body or an organization. Excuse me, I said that wrong. Political body is defined as either a party, no, not as a party, but as an organization. It includes organizations. That's what I'm trying to get to. An organization is defined in that statute as an affiliation of electors who are seeking to nominate and elect a particular candidate. So the answer to the court's question is this. Affiliation with the national party is completely irrelevant, in our opinion. What is important is the fact that we are a political organization, my clients are, because they are an affiliation of electors who through their desire to nominate and elect a particular candidates, in this case, Dr. Stein and Dr. Ware, are also affiliated with electors across the United States who have obtained ballot access. It's not the affiliation between the Georgia Green Party and the Green Party of the United States that counts. It's the affiliation of my clients as a political organization, affiliation among themselves, and their affiliation with other electors in other states who desire to nominate and elect a candidate. And that affiliation is very clear. I mean, the fact that Jill Stein and Dr. Ware are on the ballot in these other states, as confirmed by the secretary, validates the fact that we are affiliated by that desire. That's the statute. That's the definition of organization, the affiliation of people who desire to nominate and elect a certain candidate. So we are, in fact, affiliated with all of those other states, and the national party's affiliation simply is not relevant to the question, in our opinion. I hope I'm getting my thought across as to whether you agree or disagree. I hope I'm at least getting my thought
No,
across.
you are getting your thought across. I think what I'm struggling with is this background of, I understand there's some explanation in the briefing about the nature of the disagreement that led to an ending of a formal affiliation between the Georgia Green Party and the National Green Party. But then there's this new entity, the Unified Green Party, that I think became into existence in the last year or two. I don't exactly remember, but a new entity that has checked all the boxes and qualified electors for the same candidate. I mean, that is factually correct, right?
I can't agree with that because I
Okay.
don't agree they checked the boxes. I think they
Okay.
did not check the boxes, and the secretaries allowed them to just simply
And what
come
boxes
through
is
the
it
process.
that you think they have not checked that you have?
Well, number one, they weren't they didn't register with the Secretary of State within 60 days of their formation. Now, they did file some kind of registration at least 60 days before the election, so that might not be a box. But what they clearly did not do was they did not conduct nomination conventions,
Convention.
and they didn't file affidavits of or declarations of candidacy with certified minutes of the conventions attached. And we know they didn't do those things, so they can't possibly have checked the boxes. And that's where the risk comes in this case, Your Honor. If it's ultimately decided in these other actions that the unified party did not check the boxes, and they get thrown off of the ballot, and we are found to be not qualified because we're somehow not affiliated with the other states and their electors who desire to nominate Dr. Ware and Dr. Stein, then Jill Stein and Ware are off the ballot, or at least they can't be voted upon. And I understand there's some ruling from the court that's actually telling the counties to put up a poster saying, I think it's Cornell West is on the ballot, but you can't vote for him, or something to that effect. There's a real danger in following the path of the secretary and saying that, well, I'm just going to let it go through the unified party, because there's serious and grave doubt as to whether or not a court will ultimately find that they checked all the boxes. So I think by affiliation among themselves, the 16 among themselves, through their affiliation with the electors in all other states seeking to nominate and vote for a set of candidates, that is all the statute requires. And for this appeal, what we're asking you to rule is that because of that affiliation, these 16 electors were in fact qualified. That's what we're asking for, is that they were in fact qualified, and it was error to rule that they were not qualified. And if the court stops there, we'll be completely satisfied. We'd love for you to rule about the unified party, believe me, but I'm not going to take it that far at this point because you've already recognized the problems with that in the record. But all we're asking for is you to find that we were in fact qualified by reason of that affiliation. And that's it in a nutshell, to be honest with you.
Okay. Thank you very much, Mr. Webster. Mr. Varghese?
Thank you, Your Honor. So we certainly don't agree with all the findings of the ALJ or the secretary in this case, but they did correctly find that the Georgia Green Party has not gained ballot access in 20 other states. And whatever else OCGA 212172G requires, at minimum, it requires that. I appreciate Mr. Webster's argument about how they may be affiliated in concept or spirit with people in other states, but that doesn't make them. First, let me step back and say the definition of political body refers to the electors affiliated amongst each other, and this is through the definition of political organization, Your Honor.
Right. I'm looking at it. The joy of having two screens. I'm actually looking at it on Westlaw right now.
Great. And I'm paraphrasing, but for the purpose of influencing policy through the nomination of candidates for office under, it's either under the laws of the state or as provided in this section. And so really the definition political body is how do you constitute a political body in Georgia to nominate candidates pursuant to Georgia law? Setting that aside, we know that this political body has not qualified for ballot access in any other state. And even if we go beyond the plain text of the statute and we look at has any affiliated body affiliated with this political body gained access, the answer to that question is also no, because they're not affiliated with the Green Party of the United States, whose nominees are Jill Stein and Dr. Ware.
Okay. So what of the sort of threshold question, though, that Mr. Webster raises, that the insistence on setting aside the affiliation issue, right, which was a new issue raised by the Secretary of State, which I believe procedurally, legally, he's entitled to do because he's supposed to conduct a full review and make a ruling. But setting that aside for a moment, what about this threshold argument that essentially that the rulemaking process undertaken by the Secretary of State was arbitrary and capricious in terms of the timeline being functionally creating a deadline that could not have been met by any political body?
Your Honor, respondents here, petitioners below, don't take a position on that argument. Obviously, the Secretary in a different context has found someone satisfied the administrative guidance put out.
hang on. Let me back up. So the briefing that I've read, the Mr. Webster's clients clearly take the position that the date of the 23rd of August was too early. And the only legal way to phrase or frame, at least to my mind, that argument is essentially a deprivation of due process or an arbitrary and capricious rulemaking process. I understand that's not the ALJ acknowledged that argument and said, yeah, but that's not dispositive of the outcome here. But what about that issue? I mean, Mr. Webster puts it front and center. And I guess the reason I asked that question is because if Mr. Webster is right that the lack of a formal affiliation between Mr. Between the National Green Party and the Georgia Green Party that the Secretary of State referenced is not dispositive of the outcome, then you're back to their inability to demonstrate ballot access in a number of states, which Mr. Webster's, I think, primary argument is, well, we were in the process of doing so, but we couldn't by the date that we were required to do because it was too early. What of that issue?
On that issue, respondents here take no position, Your Honor.
No position. Okay.
Your Honor, I apologize for the interruption. I'm
Yes.
Elizabeth Young. I represent the Secretary of State.
Yes,
May
ma'am.
I, just for informational purposes, say a few things about that that I think would be helpful to um,
Well,
provide some of the information
I
that you may be
certainly would
seeking.
welcome the guidance and the expertise, but I do want to acknowledge to the point of, I think, a supplemental affidavit that's been filed, that those things are technically outside the record. And, we want to make sure that we're following appropriate procedure. But to the extent, Mr. Webster, if you don't object or want to reserve the right to object, same to Mr. Varghese, I would welcome hearing from Ms. Young.
Your Honor, I would be okay with Miss Young sort of presenting an amicus type argument to the court just for knowledge and edification. I don't have any problem with that. I do agree with you that we have to be careful with what the record shows and what it does not show. But
Okay. Thank you, Mr. Varghese.
I have no objection to the same. Thank you, Your Honor.
Thank you. Ms. Young, thank you.
Sure. Just, for some background, the Secretary had to consider for the first time how to implement this new statute, 21-2172G, which was passed at, close to midnight on sine die, without a whole lot of discussion or input on the front end. And it's a very, clear, but also very brief directive. This is notwithstanding any other law to the contrary. If it's a political body that has ballot access in 20 states, they will be their electors will be qualified and they'll be put on the ballot. So the Secretary had to then try to figure out how to implement that rule. And that posed a number of questions that have come up in this case. One of them being that statute doesn't have a deadline. As a practical matter, the Secretary at a certain point has to know who's going to be on the ballot. And so the Secretary issued some guidance giving a deadline. If I remember right, I think it was the 21st or 20th of August off the top of my head. And that was just sort of a practical deadline that, when they looked at the calendar, they were like, okay, we got to kind of know by this point. In terms of ability to prove, it is difficult. Mr. Webster has a point because different states run different schedules, and at this time, things are very much in flux, and sometimes it's not entirely clear when a state is officially putting somebody on the ballot because it can be a process that has several steps to meet. But the Secretary did an independent review based on the application of the Unified Green Parties that put together the paperwork on the 20 state issue, sent in a submission to the Secretary, which, advised them of what they thought the 20 states were. And the Secretary then took that information and verified it with the various states. From that point forward, the secretary determined once the secretary determined there were in fact 20 states. There were some other regulatory requirements that the Unified Greens had not yet met. They have since taken care of those, but the secretary was guided, primarily by the language that said, notwithstanding any other law to the contrary. If they get the 20 states, you put them on the ballots, you qualify the electors, period. So at this point, ballots are printed, and the purpose of filing the affidavits from
Well,
Ms.
not
McGall.
forgive me for
Sorry.
interrupting you, and not to be, I don't wish to be overly adversarial, but one of the points that Mr. Webster makes in his presentation and briefing is that in a number of states, it's not actually the Green Party that Dr. Stein and Dr. Ware appear on. It's like the Mountain Party or the whatever. And I don't know the extent to which those are included in the list of 20, but it does seem to necessarily have to come down to what is a political body and to what extent do those political bodies have to be affiliated with one another, a la the affiliation of electors organized for the purpose of, influencing government elections.
So the statutory definition of political body in the election code is very, very abbreviated. It's anything other than a party.
Right.
So, there are statutes that talk about political bodies that have nominating conventions, but neither the definition of the code nor 212172G speaks to the requirement of a nominating convention. I don't have the depth of knowledge to answer questions about how Ms. Stein obtained ballot access in each state. But, of course, if the court has any questions, we'd be happy to get that information.
No, I mean, the only reason I mention it is simply because one of the conversations we're having, and again, this is somewhat outside my purview because it relates to the Unified Green Party's application, which is not before me. But to the extent it touches on what we're dealing with, I was simply asking the question if 172G talks about a political body obtaining ballot access, then to what extent does it have to be demonstrated that it is in fact a political body that's gained access rather than a candidate that has used various disparate political bodies in various states to gain a concerted access? Because, some people go into a ballot box looking for the Republican Party or the Green Party or the Democrat Party, but some people go into the ballot box just looking for the name, and it doesn't necessarily matter what party follows. And so that's the reason I asked the question, is that I don't think anybody challenges that Dr. Stein and Dr. Ware have gained access, but does it matter that that access may have come using different political body vehicles in different states? And the reason I ask that is that if in fact it does matter, then does the lack of affiliation between the Georgia Green Party and the National Green Party matter if in fact there are entities that are not affiliated, that are gaining ballot access for this individual candidate?
Well, and I think that that a lot of that probably goes beyond the limits of my knowledge. What I do know,
I'm sorry.
that's okay, yeah, and I'm happy to go get the knowledge to the extent that the court needs it to make well-informed decision. But what I do know is that the secretary, reviewed the information submitted by the Unified Greens and checked with the states and, made the determination that application had met the requirements of 172G. I will say, neither 172G nor 21223 really place any limitations on what a political body is. It's basically an organization. I mean, so we talk about affiliates, and I don't know what the structure or formality looks like in terms of affiliates. I had never heard of the Mountain Party until you mentioned it just now.
I'd never heard of it either until I read it in Mr. Webster's brief. So,
but and we've had a lot of briefing in this case and many cases, so I'm still trying to figure out all of the moving parts too. But can certainly provide more details if needed, but I did want, what I do know in general is that the secretary, in making a decision based on, his knowledge and expertise of how to implement election code rules and how people qualify for ballots, did do a review, going beyond just looking at the application, but did do their own investigation on some level to satisfy themselves that the 20 state requirement had been met for the Unified Greens application to be given the access under 172G.
Understood. Thank
So,
you, Ms. Young. I do
and
appreciate your addition of your expertise here.
sure. And if I may say one more thing, as it stands right now, ballots have generally already been printed listing Ms. Stein as the candidate, and all it says is Green Party. It does not say Georgia. It does not say Unified. So,
Which also begs one question that I was going to ask to the attorneys, which is if right now, at least for the moment, right, the candidates that the National Green Party, such as it exists, wishes to put forth, which are Dr. Ware and Dr. Stein, they have the right currently to be on the ballot based on the Secretary of State's initial approval that has now been an initial decision from the ALJ and a final decision from the Secretary of State that were handed down yesterday, subject to appeal. And so one question is, if in fact they're going to appear on the ballot, do I have to decide this issue right now under the gun with limited briefing and time for review of the record? And not that I would, decide it a month from now, but at least to determine what's going to happen to the unified party. Because I understand Mr. Webster's concern is, what if I say no, the Georgia Green Party isn't affiliated with the National Green Party, and therefore it's not, it did not demonstrate that it's not a political body that was able to demonstrate that it had ballot access in other states. And then the unified party gets to some Superior Court judge, hopefully not me. And that Superior Court judge determines that the unified Green Party, to Mr. Webster's point, failed in some manner to satisfy the other, if there are any, minimum requirements, like, for example, having a convention or, a certain number of signatures or other ways that people might access the ballot. What are your thoughts on that, Mr. Webster?
Well, Your Honor, I heard your question be, do I have to rule now? And if I understand Ms. Young correctly, it sounds like the ballot as printed is going to show Stein and Ware simply as Green Party candidates without
Right.
designation.
Absent a ruling in the next 2-3 days by another Superior Court judge that said, or me, I don't know, but that says something about a flaw in the unified party's application such that there would be some direction to remove them, as there has been with, at least I think the preliminary rulings for Dr. West was for him to either not be removed or to notify voters that votes for that person will not count. So,
well, I think the answer to that question is it depends on how you rule as to what the outcome would be. For example, if some other court ruled that the unified party agreed with us, and these are the arguments advanced by Mr. Varghese clients as well in their petitions and their challenges. If a court were to rule that the unified party did not qualify because they didn't hold nominating conventions, didn't submit appropriate declarations of candidacy because they don't have certified minutes of those conventions, and you ruled that we weren't qualified, then Dr. Stein and Dr. Ware either have to come off the ballot or there has to be this very strange outcome of leaving them on the ballot and simply putting up a poster saying, if you vote for these people, it won't count because we've determined after the ballots were printed they shouldn't be on there. If you were to rule in our favor on this, now this is not really a good reason for you to rule in our favor, but I do think it's relevant to talk about the outcome. If you were to agree with us on this, it's almost a safety valve for the sanctity of the ballot itself, because if we are qualified and it's later determined that the unified party was not, then there's no reason to take them off the ballot, because they would stay on simply as Green Party candidates as nominated by the electors that I represent in this case. So we really represent the safe harbor of this issue, in my opinion. But I would like to address one thing that's been talked about, and kind of bring it all together like this. What this boils down to is the interpretation of 172G. And the statutory interpretation of that is soundly within your discretion and your jurisdiction, as in this case, as an appellate review. And what has happened in this case is that the secretary has modified the language of this statute on several levels. Number one, he put a deadline on it of August 20. It's August 23rd, by the way, Elizabeth. He put a deadline on there that does not match up with the other states. And what really tells the tale, Your Honor, is that in Exhibit B, the secretary admits that by August 29th, that question had been answered. That Stein and Ware on the ballots in 20 states at least, and that's no longer a reason to disqualify any party. But they had already made their ruling on us on August 26th. He also included this stuff about submitting affidavits and supporting documentation. There's nothing in the statute that requires that. And then finally, as you pointed out, the ultimate changing of the language by the secretary was when he decided, well, you have to be affiliated with any other party that's got ballot access. That misses the point altogether, and it's just not the law. It's not in the statute. It's nowhere in the law. Affiliation doesn't exist in the code except for this definition I gave you about political organizations. So the focus must be on what a political organization exists to do, and it is an affiliation of electors desiring to nominate and elect a candidate for public office. And that is an affiliation my clients share with all of the Greens across the nation, regardless of whether they're the Mountain Party or the Green Party or an affiliate of the Green Party of the United States.
Well,
It's
except
just the
that,
same affiliation.
well, but this is where I'm still confused, right? Is that if there is a way to be formally affiliated with the National Green Party and the Georgia Green Party is not, then doesn't that mean that although in spirit and in purpose you might be affiliated with them, you are not actually affiliated? Or do you want me, are you, is your understanding that the phrase affiliation of electors doesn't mean some formal affiliation? It's about the purpose and the intent behind what those electors are seeking to do.
What we are asking you to rule is kind of two things. Number one, affiliation is not in the statute. There is no requirement under 172G that your political organization must be.
No, I'm not arguing with you about that, but
okay, but if I may
terms have to be read in paramateria with the rest of the statute. And there is the word political, the phrase political body is in 172, and it is defined through about two steps, because why wouldn't it be, as an affiliation of electors. And so, I mean, a political body means an organization other than a party, and an organization is defined as an affiliation of electors. So I don't know that it's that far of a stretch to require some affiliation. The question is, what is the degree of affiliation that's required?
Yeah, we're almost together on that, Your Honor. I'm hearing you say, which I agree with very much. What does affiliation mean? Does it mean it has to be a contractual affiliation between the Georgia State Party and some other party in the United States? Or does it mean that it has to be an affiliation as defined by the legislature, only an affiliation of electors desiring to nominate and elect a candidate? I think our position is far more consistent with the law that exists in Georgia. Reading these statutes in pari materia, I very much agree with you on that. I think our position is far more supported by the law than it is to say, well, you got to show an affiliation between this party and that party, because that argument ignores the concept of political organization, which is a whole different thing. whether the Green Party of Georgia as a political body is affiliated with the Green Party of the United States as a political party doesn't matter. What matters is, are these electors affiliated with other electors in seeking to nominate and elect a candidate? That is the proper interpretation of these statutes, reading them in para materia, as the court has said you do. Honestly, Your Honor, I don't mean to be overly, pushy about this, but I think that's the only way this can be resolved. To stick on this requirement that parties be affiliated and all that stuff is so far afield from what this simple subparagraph G says. How can you defend it? I mean, how do you deal with it? I mean, it's just indefensible. That's all there is to it. And again, I appreciate you listening to me on it. I hope I'm getting my point across.
Thank you, Mr. Webster. Mr. Varghese? Mr. Varghese?
Um, so I agree that the plain text of 172G is fairly clear, right? And it is any political body that has obtained ballot access in at least 20 other states. Neither the Georgia Green Party nor the Unified Green Party of Georgia is a political body that have achieved ballot access in 20 other states. I agree with Mr. Webster to the extent that he says looking for affiliates obtaining ballot access goes beyond the text of the statute. I agree, it does. And so unfortunately, it doesn't help Mr. Webster's client. It just puts them in the same position as the electors for the Unified Green Party of Georgia, in that neither of those political bodies have obtained ballot access in any other state. And so therefore, neither of those organizations satisfy 172G. And I will say there may be a third step in understanding what political organization or what political body means, because political organization says, organized for the purpose of influencing or controlling the policies and conduct of government through the nomination of candidates for public office. Well, nomination is also a defined term in the election code, and it means the selection in accordance with this chapter of a candidate for public office authorized to be voted for at an election.
Which the Georgia Green Party says they satisfy.
They say they satisfy that, but they haven't, because the means through which they say they satisfy that is 172G. To be clear, the question before the court here is with regards to the Georgia Green Party, but respondents here's position is that neither of these Green parties have obtained ballot access in any other state, let alone 20.
Right. That part I understand, but I think, or I may be mistaken, but I thought that the distinction that primarily you would probably argue that neither entity has demonstrated that they have secured ballot access in 20 states or more. But the underlying basis, if you set that issue aside, here is about whether or not they have demonstrated that access, how you go about doing it in a timely fashion, et cetera. Whereas I think I understand the issue with the Unified Party is they didn't go through any of the traditional processes to put forth a slate of electors.
That is correct on the Unified Green Party, Your Honor.
Okay.
Your Honor, if I may present the concluding argument here.
Well, before you do, and that's what I was going to call upon you to do, because it is your motion, your petition, so you get the last word, Mr. Webster. But Mr. Varghese, I did ask the question regarding if, as it stands right now, if I take no action, the Green Party appears on the ballot. The Green Party candidates, I should say, appear on the ballot. What is the danger in not, because the concern is always when you rule in an expedited manner that you miss something that with greater time to research and review would have become apparent. Is there a risk here for the court to pause a bit and figure out what happens. To, for example, the unified party resolution or otherwise. And let me say this. If there were a situation in which the Secretary of State says unified party satisfied all the boxes and that gets affirmed by the Superior Court, then theoretically, I could sort this out later when we decide who gets ballot access next year, or excuse me, 4 years from now, if there's satisfaction of the 1%. Is that true, Mr. Vargas?
On the last point, I'm not entirely certain. I don't think, obviously, that's a decision that will be made in 4 years and not today.
Mm-hmm.
To the court's prior question as to whether there's danger in delaying here, I think because in this decision, the secretary found that these electors were not qualified for the ballot, but nonetheless, in another decision, found other electors representing the same candidates for office to be qualified. I don't think there's an immediate urgency in ruling in this action.
Okay. Okay. Mr. Webster, it
Thank
is
you,
your
Honor.
petition, so you get the last word, sir.
Thank you, Honor. In answer to your question about dangers and delay, naturally, we would love a quick decision on this so we can decide where to go with it. But as long as Ms. Young is correct that the ballot shows Stein and Ware listed simply as Green Party candidates, then what you're ultimately deciding, as I said earlier, is which party gets credit for that. If you were to rule that we are not qualified and another court rules that the unified party was not qualified, then we wind up with a chaotic result of either taking Stein and Ware off the ballot or telling voters that if you vote for these people, it won't count. That I don't think anybody would disagree. That's a chaotic result. So anyway, having said that, here's what we are asking the court to do. There were two reasons given by the ALJ and the Secretary of State for ruling that we are not qualified. We are asking you to rule that we were qualified. And the two reasons were, number one, that the ALJ found we couldn't meet the August 23rd deadline. That has obvious constitutional problems. It is completely underrode by the fact that by August 29th, the Secretary had determined that the 20 state had been satisfied. And that gave plenty of time to get the ballot right if he had ruled that way. The second reason is this affiliation thing. It is not in 172G that the parties have to be affiliated with, or the body has to be affiliated with anything. And we maintain that our affiliation amongst ourselves as electors, in conjunction with our affiliation with electors in all other states that are supporting Stein and Ware, is the kind of affiliation that should be required. And that's the only kind of affiliation that should be required. Trying to match party up by party and state after state is an enormous task that would never have probably a correct result, to be honest with you. I honestly think that the whole purpose of 172G was focused on getting candidates on the ballot, not in trying to match up parties with parties, which is what the argument has been from the Secretary. I think it was a real mistake for the Secretary to even go that route. And we're asking you to correct that mistake by ruling that we were, in fact, affiliated with other electors and that we were thus qualified to be on the ballot in this case. That's all we're asking this court to rule, is that we did meet the qualifications.
Understood. Thank you so much, Mr. Webster, Mr. Varghese, and also Ms. Young, for answering my questions. You all are, this is a new provision, but y'all are much more steeped in election litigation than am I. So I appreciate you putting up with some of my questions that might have sounded a little unformed. But in any event, I am not going to rule right now. I do, however, understand the urgency that is at stake. And so it is my intention to advise the parties of what my ruling is going to be as soon as possible. And in no doubt, there will definitely be a ruling by Monday, which is basically the best I can promise with a written order, so that y'all have some idea of what you're doing. Because as much as I would love to punt, I think that the answer does have to be, there has to be an answer now, and then figure out what to do with that answer as we go forward, and how it relates to this other Green Party issue. So that is what I will do. Do you, anyone have questions, concerns, issues they need to address with me while we are all still together? Mr. Webster?
No questions other than do you require or request of us to submit a proposed order? I prefer the court to write its own order, to be perfectly candid
Well,
with you. If
I
you need,
typically do write my own orders. That doesn't mean I don't also ask for proposed orders, because sometimes it just it gives you the law, and it helps, it's easier to edit than it is to start from scratch. But I hadn't decided on that just yet. Mr. Varghese, what were your thoughts, sir?
We have no additional questions, Your Honor, with regards to a proposed order. We'll submit one if the court requests it.
Okay. I don't think I'm going to ask for a proposed order in this case. As I said, I feel like I would, it would take more time for y'all to pull one together, and that time is the time I'm going to try and spend writing the order myself. And so we will go from there. But I appreciate the offer, Mr. Webster, and the willingness to provide one as well, Mr. Varghese. With that, we are concluded.